Yes.
That's it. Hearing item should be one. If this is can allowed. That's it.
On the prayer of Mr. Yangarwati, the learned CGSC. The case is adjourned for a week. Listed after a week.
Much obliged.
Please, Lordship.
Yes.
I beg to mention hearing item number 18. I'm for respondent 5 and 6, Your Lordship. My senior has some personal difficulties today, so if this matter can come up after 2 weeks, Your Lordship.
Okay. MS so and so, the learned counsel for the respondent number 5 and 6, submits that Mr. A. Jimomi, the counsel leading the case, has some personal difficulties and therefore seeks adjournment of the case for 2 weeks. Listed after 2 weeks.
For admission, item number 1.
Yes, Mr.
Please, Lordship.
Yes.
My Lord, this is a case seeking appointment on the basis of land ownership. The government counter is devastating. Government counter
Devastating?
has devastated my case. So I'm
Okay.
trying to read petition with the liberty to file afresh.
What was so devastating?
2 persons have been appointed on the basis of land owners on earlier occasions.
Okay.
Therefore, in view of that appointment, I'm not governed by the policy for the time being.
Okay. Mr. C.T. Jamir, the learned senior counsel for the petitioner, submits that he has instructions to withdraw the writ petition with liberty to file afresh. Stop. The petitioner is allowed to withdraw the petition with liberty to file afresh. Okay.
Much obliged.
For admission, item number 2.
Please, Your Lordship.
Yes.
Your Lordship, another 2 weeks may be granted, Your Lordship, for obtaining instruction, Your Lordship.
Who are the parties? Union of India?
The Union of India has filed their affidavit, Lordship.
Very unusually.
They have filed a reply.
Yes, and MS Livika, you are for?
I'm for the state, Your Lordship.
State is also necessary? It's
Your Lordship, it seems that the petitioner has said that we need to clarify on one document, Your Lordship, and for that I have sought for instruction, and that instruction is yet to reach me. It is necessary for me to give instruction on that document.
In fact, Lordship, here the prayer of the petitioners is that the petitioners have submitted a presentation to the DC in Lahore, praying to conduct re-verification of their domicile and residential certificates, because the appointment of the petitioners were withheld because the authority, the Union of India, has conducted the interview. They suspect that the domicile and the residence certificate of the petitioners are either fake or not proper. That is so. The petitioners have giving a representation to the DC for conduct re-verification of the. So the Lordship can either pass an order directing the DC Dimapur to conduct re-verify the documents of the petitioner's Lordship. The representation is page 85.
Who has issued a domicile?
The Dimapur DC Lordship.
DC. And the residential certificate?
Dimapur DC Lordship.
Got instructions? Okay.
Yes, sir.
MS Livika. The learned counsel, the learned government advocate for the respondent number 3 submits that he may be given another 2 weeks' time to receive the necessary instructions from the respondent. Prayer is allowed, listed after 2 weeks. You make an endeavor.
Yes, Your Lordship.
Lordship, there's an interim.
The interim order passed earlier shall continue till the next returnable date.
For admission, item number 3.
Yes, Mr. Incham.
Lordship, there was a direction by this Honorable Court.
Yes.
Lordship, can you see the order date? 29/5/2023.
29/5?
2023.
Okay.
This Honorable Court has directed the state respondent to conduct a meeting with the village authorities, the clan,
20. What was the order? 20?
29/5/2023.
29/5. Okay. Doing. What is happening is that three
Fourth
VCMs
paragraph, Lordship.
of the Kikon
Mentioning
clan
that this
is
issue is born.
selected, nominated by the Kikon clan as whole. The Learned State Council and the Learned Council for the private respondent number 4, 6, and 7. Our state submits that there are 3 sub-clan of Kikon clan in Nungyang village. Those selects the respective VCM. It is the case of the government as well as the private respondent number 5, 6, and 7 that the 3 VCM from Kikon clan are not selected, nominated by the Kikon clan as a whole, but by the respective sub-clan. No affidavit has been filed on this issue by the Learned State Council as well as considering that this issue is the bone of contention between the petitioner and the respondent. It is felt necessary to direct the state to properly clarify by an affidavit as to whether the VCMs of Kikon clan in Nongyang village are elected, nominated by the clan as a whole or
That is the issue.
by the sub-clan.
That is the issue.
The state respondent, particularly the respondent number 3, is directed to submit a report on the issue in consultation with the village authorities of Nongyang village as well as the members of the Kikon clan of the village. The affidavit shall be filed by the Learned Senior Government within a period of 2 weeks. The affidavit shall also clarify whether Kikon clan of Nongyang village has any sub-clan.
Yes.
The affidavit is... Yes, Mr. Anangami,
Lordship, I have already filed.
you have filed your affidavit.
Lordship, I have filed it on 16/6/2023.
Okay, and what about a private respondent?
As I read it, for this number, I'm just relying on whatever I did as sanitary credits.
Lordship, as per the direction of this Honorable
Where is
Court,
your affidavit, Mr. Nangami? What is your affidavit dated?
16/6/2023.
16/6/2023.
so it has been clarified there is no sub-clan, Lordship. The Kikon clan have got 3 families. There is no sub-clan, as claimed by the private respondent, Lordship. Paragraph 5 will explain, Lordship. Paragraph 5 of the affidavit.
That in this
I
regard,
have received a copy, Lordship.
the government respectfully
Where it has been
states-
clearly stated,
Just wait, let me also read.
Lordship.
The thing is, government respectfully states that this honorable government has by the already directed as to whether the VCMs of Kikon clan in the new village are selected, nominated by the clan as a whole or by the sub-clan. In the order, it was further directed that the Deputy Commissioner Who is the respondent number 3 in the presented petition to submit a report on the issue of consultation in consultation with the village authorities of New as well as the members of the Kikon clan? This Honorable Court has also further directed that the affidavit shall also clarify whether the Kikon clan of New has any sub-clan. That the answering respondent respectfully states that as directed by the Honorable Court in the order dated directing the respondent number 3 to submit the report on the issue in consultation with the village authorities as well as members of the Kikon clan of the village. The Deputy Commissioner Oka has by the later dated submitted the verification report of the Extra Assistant Commissioner Chokitong Oka to the Advocate General Nagaland, wherein it was stated that the concerned area has a consultation with the village authorities and members of the Kikon, and report is based on the clarification provided. And as was directed by the Honorable Court, a verification was conducted and a report of the same was submitted by the Extra Assistant Commissioner to the Deputy Commissioner Oka through its letter by in the verification report. It is stated that the verification was conducted on 86 by calling a meeting of the new village authorities and representatives of the 3 Kikon subclans. In the report, it is stated that with regard to the clarification sought by the Honorable as to whether Kikon clan also has any subclan, it is clarified that there is no subclan in the literal sense of the word. However, the Kikon clan is divided into 3 family trees. Each family line is entitled to a seat in the VCM body. Hence, the word subclan has been used for a lack of better words. In the verification report, it is also stated that with regard to the clarifications of the Honorable as to whether VCM clan are selected by the clan as a whole or by the subclan. It is clarified that each subclan nominates a representative of its own, but in consultation with the whole clan. Okay. So there is no subclan,
No subclan.
but there are
3 family.
3 family descendants of 3 families,
3, yes.
and
The election is done by the whole clan. One,
it is clarified that each subclan, that is family tree, elect, nominates a representative of its choice. So the first thing is that each family tree
yes,
will nominate a representative of its choice in consultation with the whole clan.
whole clan.
Don't bank only on the word whole clan. Read before that also.
No, sir.
It is clarified that each subfamily nominates a representative of its own clan, but in consultation with the whole clan. So what is your case now?
Now, Lordship, there's a manner in which the prime respondent in connivance with the GB, because GB has nominated by himself the GB.
Who is representing the GB?
My lord,
You are representing?
JD. That one is the one plan by one subplan.
You are representing respondent number?
5,
5,
6,
6, and 7 marks.
5, 6, and 7. 5 is the head GB.
And who is for 8, 9, 10? Who are this? Oh, okay.
Only I think 7.
Yes. 5 is head GB.
Yes. 6
is
GB.
GB.
And 7 is the nominated member of respondent number 6. Respondent number 6 has nominated 7 and 5 has ordered to the clan without the consultation of the clan. That is my case, Lord.
And this 7 has been nominated without the consent of the clan.
Yes, that is my case. Because the petitioners are all members of Kikon clan. There are together 22 of them.
But the R6 is also Kikon.
Yes. He is the GB of the Kikon clan.
Huh? So what is wrong?
Now, Lordship, you kindly come to the annexure B. This is the genesis of how the whole issue came up. Annexure D, page 34, Lordship.
Annexure B.
D, page 34. Lordship, may I kindly see the type of page 35. He has directly written to the Ex-Assistant Commissioner regarding the nomination of respondent number 7. This is a letter of respondent number 6, Lordship. I'm able to read, Lordship. To the Ex-Assistant Commissioner.
Yes, wait. This is the letter written by respondent number
6.
6.
To respondent number 4, the Ex-Assistant Commissioner.
You were submitting that respondent number 5 had actually forwarded the case.
5 is the authority who submits to the government. But here in this case, he has also written a letter. Respondent number 6 has written a letter to the EAC with regard to nomination by him. Names are forwarded, Lordship. Page 36 is the common letter of the nominated letter. 35 is his own capacity as GB. He has nominated the respondent number 7. And actually, he is the head GB letter sending the name of the PCM of the English.
So what is wrong in R6 nominating the R7? What is wrong? R6 is also from Kikon clan.
Yes, but what Lordship, his selection nomination was done without the consultation of the king. Lordship, the report of the district administration is before its honorable court, Lordship. Paragraph 5, it has been made clear. They select, the three family tree will select one member in consultation with the whole clan, which was not done in this case. Lordship, I may be allowed to read the letter of the R6, Lordship. To the Ex-Assistant Commissioner, Chikito Woka Abel.
Yes.
Subject, I, Sri Jumo Kikon GB, have no objection to allotting the same post to Sri Jumo Kikon from my sub-clan entity. In view of the subject stated above, I have the honor to say that I, Sri Jumo Kikon, this R6, have no objection for allotting the same post to Sri Jumo Kikon as the same post. It solely belongs to my own sub-clan. He's using the word sub-clan. There's no sub-clan, Lordship.
Okay, that doesn't matter.
Yes, and the village authority and HB have already qualified his member as PCM post as afforded for my clan to Sri Jumo. Therefore, I earnestly request your esteemed authority to reject the complaint level by some person.
So from one of the sub-clan of this Kikon clan,
Yes,
this R6 has nominated R7.
yes.
So what is wrong there?
Now the Kikon clan, Lordship, has nominated before. Lordship, I can come to page 32.
No, you please clarify this first, 35.
Yes. No, Lordship.
What is wrong? Because actually this GB is also from one of their trees,
Yes.
family
But-
trees of the Kikon clan.
No, Lordship. He is a GB. And the Kikon clan, they have got 3 representatives.
He is from one of the clan.
He's one of the clan, from one of the clan.
So what is wrong?
But his nomination was not on the basis of the whole decision of the clan. Because the whole clan has already...
How do this court prove that? How will this court prove that?
No, that's why I'm relying on the election C, page 32, where the Kikon clan have nominated Mr. Bhabemo Kikon. That's why the whole clan is before court. Because the GB is doing things on his own, without consulting the clan. The GB has acted beyond his authority, without informing the clan.
Okay. From your petition,
Lordship.
can you tell this court
Lordship.
which are the petitioners which belongs to this GB clan from this petition?
Lordship, that I have to...
Then? How this court will assert on that?
No, Lordship.
You assert on that and come.
Lordship, the issue...
You are saying that actually the respondent number 6 has nominated respondent number 7
Lordship.
without the consent of the clan members.
Yes.
Who are those clan members in the petition?
The whole Kikon clan, Lordship.
The whole the clan, the sub clan.
Lordship, that basing on the affidavit of the state respondent, because the whole clan was called. So they
See,
have stated that they are three...
affidavit of the state respondent says that actually a person is recommended by one of the family trees,
Yes.
by one of the family trees with the consent of the whole clan.
As far as the present family tree is concerned, the
Who are the petitioners from the family trees?
we are let's say,
List it and come. List it after a week.
pleasure.
Yes.
For admission, item number
4.
Yes.
Your Lordship, the pleadings are complete here.
What is the case about?
Your Lordship, it's on land ownership basis. Petitioners. Pleadings has been completed, my
They
lord.
were listed for hearing.
Yes, Lordship.
It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing. Listed in the usual course. Okay.
Obliged.
for admission, item number 5.
May I please, Your Lordship?
Yes.
Your Lordship, on behalf of VGMO, the affidavit has been sent for vetting. So kindly let the matter come up after a week.
The learned government advocate submits that the affidavit has been sent for waiting, and therefore the matter may be listed after a week. Prayer is allowed, listed after a week.
For admission, item number 6.
Yes.
Yes, may I please, Your Lordship? Your Lordship, my seniors in disposal, let the matter will come up after 3 weeks, Your Lordship.
What is the matter about?
Your Lordship, in regard to the land ownership,
Mr. So-and-so submits that. Who is your senior?
Estamjan, Your Lordship.
Mr. Estamjan, the counsel leading the case, is indisposed, and therefore seeks adjournment for 2 weeks. Prayer is allowed, listed after 2 weeks.
For admission, item number 7.
May I please, Lord, sir?
Yes.
Lord, sir, I have received the appeal opposition filed by the government. Allow me 3 weeks time to file my...
Mr. So-and-so submits that the learned counsel for the petitioner submits that he may be allowed 2 weeks time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed. Listed up to 2 weeks.
What's your
For admission, item number 10.
This your lordship.
Yes.
Affidavit in reply is due to be filed. At 2 weeks time may be granted.
What is your case?
It's about regularization.
Who's for the government? Devika, you're for the government?
Your Lordship, the matter is handled by our senior morning Your Lordship. He has his feet in the other court, Your Lordship.
The government has filed affidavit.
Yes.
Mr. So-and-so, the learned counsel for the petitioner submits that he may be allowed 2 weeks' time to file the affidavit in reply to the affidavit in opposition filed by the state. Prayer is allowed. Listed after 2 weeks.
Lordship.
For admission, item numbers 9 and 10.
Yes.
May I place a motion?
City.
Item number 10 has been filed earlier, and during the pendency of the item number 10, 9 has been filed subsequently.
Yes.
WPC number 129 of 2020 has been filed, seeking a direction to the respondents or to consider the case of the petitioner for appointment on the basis of landowner. During the pendency of the writ petition, another person was approved against the post for which I have applied. And subsequently, that approval order was challenged by way of filing another writ petition. That is WPC number 162 of 2022. And the respondent number 5 is represented by my learned friend R. Keralo.
In WPC 162.
Yes, and a contention has been taken that the appointment of the approval of respondent number 5 has been done in terms of a direction passed by this honorable court in another case to consider his case for appointment on compassionate ground, and the approval was accorded for appointment against that post on compassionate ground. So, in the subsequent writ petition, that approval has been challenged. While issuing notice, the approval order has been suspended. Now, there is another development. In the same establishment, a person expired and another vacancy has been arrested. If Lordship places and subject to what the government says, on the land ownership, they are also raising some issues, but those things Lordship may direct the government appropriate authority to verify, as Lordship has passed orders in the other cases recently. Let the competent authority verify with regard to the title of the land, whether I'm eligible or not. Those things can be considered. And so far as the vacancies are concerned, Lordship, since admittedly there is one vacancy at the moment, besides the one where the respondent number 5 has been approved for appointment on a compassionate ground, I need not disturb his case. And if a direction is issued to consider my case against that vacancy, I have stated in paragraph 12 of the affidavit in reply in the subsequent writ petition. And with regard to the title, let the competent authority verify. And
What is the stand of the government?
Contingent.
What is the stand of the government?
Government is saying that the petitioner has failed to make out a case that the petitioner could not protect how he is the owner of the land. But so far as the industries department is concerned, we are the one who came subsequently. Initially, an agreement was entered with the landowners and the Public Health Engineering Department way back in 1981. and 3 acres of land has been acquired, and agreement has been met, and there is a clause that is particularly clause
Now,
4.
what is the stand of the government so far as you are concerned? Whether you are the landowner or not, what is the stand of the government?
We are not specifically saying that the recommendation and NOC given in favor of the petitioner, there is no specific stipulation that he is owner of the land. That is the only he is saying. They are saying. On the other hand, they are also saying that we are a stranger. Actually, PHE.
That means the government is not admitting to your statements that you are the landowner. So there is a dispute as to
That's
whether you are the landowner or not.
Yes.
There's a dispute.
Therefore, if that is so, let the direction be issued to verify whether I am really entitled or not. That may be verified in terms of the clause 3, subclause A of notification of 5th March 2018. In that process, nobody will be prejudiced, Lordship. And the Department of Industries and Commerce are saying that, look, initial acquisition of land was done by the PHED department because what happened, Lordship, it is in Mangalumba Dam. Up to the establishment of the dam, few government establishments are required to be started. Therefore, it was the PHE department who has acquired a prime location of the land, which is 3 acres. And in due course, ETC establishment was also set up there. Other departments were set up there because the land is very gentle slope and many departments can be accommodated. So it is not only the PHED department, but many other departments were located in that particular area. Now, the Industries and Commerce departments are saying that, look, our allotment is by the Additional Deputy Commissioner, Mangalumba, and initial agreement was entered with the PHED department, not with us. Because in paragraph 4 of the agreement, it is clearly stated that preference shall be given to the landowners for appointment in the grade 4 post. That condition is already there. We are saying that no, this condition we are not obligated to comply with this.
You have that original agreement.
Yes.
Whether you have a copy of that original agreement.
It is enclosed in the writ petition.
Okay.
In both the writ petitions, it is included. It is
And when was the agreement dated?
1981.
81.
So prior to the notifications which are issued by the government. So in order to resolve all these issues, if a direction is issued, let the district administration verify, and the department should also be involved.
So,
Thereafter, they can.
So, Mr. Iralu, you are actually
This respondent number 5.
you are not a party in, or you are a party in both the writ petitions.
I mean, the first one, I'm not a party.
In
Because after filing the first petition,
129,
He's not a party.
you are not a party.
Yes.
So
after
what?
filing the first petition by the present petitioner, I was appointed on regular basis as per the earlier direction already given by the court in 2019.
To appoint you on compassionate appointment.
Yes. So in this petition, they have.
So what is 129?
129, I have filed the writ petition claiming appointment on the basis of land ownership. But while during the pendency of this writ petition, the post against which I have
Claimed.
respondent number 5 in the WPC 162 of 22 has been approved for appointment.
Correct.
That is how I have challenged his approval, because once his
You have challenged his approval in
162.
162.
Yes, because
So what is the relief sought in 129?
to consider for appointment on the basis of landowner.
You.
But when my petition was pending, by ignoring all this, they have approved the respondent number 5 in the subsequent case.
Okay,
for
but
appointment.
in 129 you have
So-
not completed.
Yes, because that time there was an existing vacancy and he was not approved by that time. But during the pendency of my petition, he was approved for appointment against the post which I have been claiming. Therefore, I have to challenge his approval order. That is why there are two writ petitions, but claim is only one.
I'm not getting you.
Uh,
Let us see that. Let us see your. Let us see this WPC first. 129. What is the relief claim? Let us see. 129.
Lordship, can we come to the agreement?
So let us just see the relief sought in 129. Direct the respondent authorities to consider for appointment of the petitioner to the post of Chowkidar. Okay, so in 129, you were seeking only for a direction
Yes.
to appoint you.
Yes.
In the meantime, the other person was appointed,
Yes.
and therefore you had filed this WPC 162,
Yes.
also challenging the appointment.
Yes. Since once he is appointed, then the case for consider my case will frustrated. But luckily or unluckily, after his approval, again one vacancy arose in view of date of one person. In the same
So
establishment.
now you are not aggrieved by the appointment of the other person.
No, I'm still agree, but then adjustment possibilities to get adjusted because of subsequent vacancy. Because after his approval, again another vacancy arose in view of date of one, not the employee, grade 4 employee.
So,
So-
Mr. CT,
Okay.
before even challenging the approval of the other person, you first have to prove that you are a lane owner.
Yes. No.
Huh?
For that lordship,
For that verification you want.
yes.
Yes, government.
May I please, Your Lordship? Your Lordship, the stand of the government is that, Your Lordship, the petitioner is claiming appointment on the basis of leadership on the strength of an agreement executed with the Department of PhD. And the petitioner is coming before the court claiming appointment before the Industries and Commerce, Your Lordship. Industries and Commerce Department has never executed an agreement with
No, you might not have executed any agreement, but the case of the petitioner is that initially the land was acquired by the PhD department by signing an agreement.
So,
And thereafter, some portion of that land was allotted to the Industries Department. And therefore, the Industries Department is bound by the agreement dated 81. That is this case.
Your Lordship.
What is your stand on
Your
that?
Lordship, because Your Lordship, if
You-
we have to go by that, Your Lordship, let the PhD be a necessary party, like that be included in the case. And the way it can be clear.
Oh,
Your
PhD
Lordship.
is not
Let it-
implemented.
No, they are not being
Ah,
included.
Mr.
It's a necessary party, Your Lordship. And
I
on
was
that
saying
ground alone, the
appointment
case has to be
in the
dismissed. Your
Department
Lordship.
of Industries and Commerce.
No,
It's
Mr.
not the PhD or can.
No, Mr.
Give the
CT.
appointment.
I think the government has also a point because actually you had initially donated the land to PhD department. And your case is that it is the PhD department which has given a portion of the land to Industries
No,
department.
no. It is the district administration. Once the land is acquired, the district administration will.
Our office
Control
is
that-
established
that-
on the basis of a land.
That is the
management.
reason why so many establishments have been allotted by the ADC. And so far as industries and commerce is concerned,
How do we link that the land donated by you to the PhD department is a land which was allotted to Industries department
Yes,
by
Your
the
Lordship.
administration?
That is the thing.
See, that link should be there.
Yes, Your Lordship.
that's why.
That's why at least you implement the PhD.
Verification.
Let us see. Let us see what the PhD says also. I think it will be necessary. That is what I feel because actually the whole crux of the issue is that you have donated the land to PhD and signed an agreement. And the district administration out of that land has donated a portion of the land to Industries.
In the government counter also, the allotment is given by the additional deputy commissioner. Mangalore.
There is no dispute on that, Mr. CT. There is no dispute on that. But how do we link that your land donated to the PhD department is also the land which was allotted by district administration to the Industries department? How do we link that? if there is some connection, we can definitely, under the clause 3 of that notification, we can issue some direction.
Lordship, acquisition is normally done by the government. And yes, it was for the establishment of the PHE SDO office. But then the district administration,
See, let us take every case on the peculiarity of that case. Let us take every case on the peculiarity of. There is no dispute that it is the government which allots the land. There is no dispute on that. But here is a case where you are actually making a submission that you had actually donated that land in the year 1981 to the PHE department. And that land, portion of that land was allotted by the district administration to the industries department.
yes,
So there should be some link to show that actually the land which was donated by you to the PHE department.
Lordship,
I-
Lordship can issue a direction, definitely.
No. I
We
think
will resolve
this
all these issues.
code is of the direction will be issued only after you implement the PHE. Kindly do that. I think it is not difficult for you, and implementing the PHE, in fact, will support your case if what you say is true. So you kindly implement that PHE department, and I think we can have a proper hearing with the participation of all these parties. Okay, Mr. Senior Advocate, please. I think, yes, Mr. Yalo, I think that should do. Yes. In the course of hearing, it is found necessary that the PHE department will be a necessary party for adjudicating the case. Stop. The learned senior counsel, Mr. C.T. Jamir, the learned senior counsel for the petitioner, shall accordingly implead the PHE as a necessary party in the case, listed after 2 weeks. Yes.
For revision, item number 11.
Yes, ma'am.
May I please, Your Lordship?
Yes.
My Lord, latest matter will come up after a week.
Why?
My Lord, the counter affidavit which I prepared is for waiting is yet to come.
And what is the guarantee that you will get within a week?
My Lord, to take 1 week's time.
What is your case, ma'am?
Lordship, the petitioners and the respondents were selected as Zilla Sainik Welfare Officer. They appeared for the exam, and the respondent number
For what
For-
post? For what post?
Zilla Sainik Welfare Officer of the districts.
Zilla Sainik officer.
Yes, Lordship.
Okay. So what is your ground challenging the appointment of the private respondent?
Lordship, when we go through the documents, they did not select the respondents as per the advertisement.
Okay.
The respondents submitted their application after the expiry of the application submission period.
Okay. Only they submitted their application only
After the expiry.
after the last
expiry,
date.
as per the advertisement.
Is it true?
Mr. Respondent number 5 and 6. You cannot do a separate count.
Pardon?
You have taken the separate count. In Mr. Respondent number 5,
How many respondents are there?
2 respondents.
2 respondents.
2 premises.
And you are for both the respondents.
Yes, 4 and 5. You should be in Mr. Respondent number 4. You are challenging on the ground that, as per the guideline issued by the central government, that is in the year 1979.
Okay.
The respondent number 4, he is a retired territorial army. As per the guideline, you are saying that territorial army cannot be considered as an ex-army man. As per the 1979 guideline.
Okay.
That 1979 guideline has been repealed by 2012 guideline.
Okay.
And as per the 2012 guideline, territorial army also can be considered as an ex-army.
Okay.
So there's no power for respondent number 4 to apply for the post in the case.
And what about the last date of application, which
And
is
the-
raised by the petitioner?
Respondent number 4 he submitted within the prescribed date.
Okay.
In respect of respondent number 5,
Okay.
you are challenging that I've submitted my application after the last date.
Okay.
Last date of submitting of application was 23rd of March 2020.
Okay.
Immediately before that, the COVID started,
Okay.
the pandemic.
Okay.
So within for 2 years it was suspended. Subsequently, the selection was held. After the relaxation of the COVID,
Whether there was any notification?
no, Rashid. But
No,
here's a guideline issued by the Zilla Sanic Working Group.
Okay.
As per the guideline, the selection has to be conducted on the basis of the panel list approved and sent by the ministry.
Lordship, in the
And as per the panel, the ministry has approved my candidature, and my name has been included in the panel. So I was called for interview.
Okay.
In that panel, yes, she has not challenged in this.
It is the ministry who had accepted your candidature
As per the then that is as per the guideline.
as per the guidelines.
As per the guideline, the panel has to be approved by the ministry.
Lordship, in the list of applicants for various posts, the respondent number
He
5.
has to challenge the petition. She has to challenge the panel. That is not.
Not-
given in the presentation.
His name was not recommended in the application list, but that will come later on.
Mr.
At the course of
Muli. When can you file your affidavit?
My lord, affidavit, my lord.
Are you certain?
Yes, my lord.
You have sent for vetting?
Yes, my lord.
Mr. Zatan Muli, the learner CGC, submits that the affidavit prepared on behalf of respondent number 1 has been sent for vetting, and therefore the learned council seeks for a week's time to file the affidavit in opposition on behalf of the said respondents. Prayer is allowed. Listed after 2 weeks. We give 2 weeks. 1 week, I think, maybe since the affidavit has been sent to Delhi. Is it?
Yes, my lord.
Yes. So we listed after 2 weeks.
My lord.
Okay.
Obliged, Lordship.
For revision, item number 4.
Please, Your Lordship.
Yes.
Lordship, I have received the counter affidavit filed by the union. So,
Okay.
the Lordship may kindly grant 3 weeks' time to file reply affidavit if necessary.
Three.
2 weeks' time.
Okay. Mr. So and so.
I, Jamir.
I, Jamir, sir, the learned counsel for the petitioner submits that he has received the counter affidavit filed by the respondent number
1 to 4.
1 to 4, and therefore 6 for 3 weeks' time to go through the affidavit and to file affidavit in reply, if so advised. Prayer is allowed, listed after 3 weeks. Okay.
Worship on Response 5.
Mr. Fuseko,
Lordship, similar prayer for item number 13.
learned counsel appears for the respondent number.
5, Lordship.
Similar prayer for
Item number 13.
same. Item 13, same.
Lordship.
Same. Item 13.
Same parties.
Okay. Item 13, same order.
Like,
Yes.
For revision, item number 14.
May I please, my lord?
Yes.
Lordship, by order dated 17/7/2023, Lordship, I was asked to get necessary information as to whether the Chief Secretary is the chairman of the Nagaland Backward Tribe Commission,
Yes.
who is made as respondent number 3 in the present writ petition, Your Lordship.
Yes.
Now, Your Lordship, I have sought instruction from the Office of the Chief Secretary, as well as from the Office of the Department of PNR and Home Department. Lordship, I have been informed that as of today, no such notification actually has been issued. So, if the petitioner has got some knowledge with regards to the this backward commission, if there is any. Your Lordship may kindly as to because Your Lordship as to how this the chairman of this backward commission is implemented. Your Lordship.
Yes, Mr.
Lord
CP,
Chief,
Chairman,
at
backward.
the time of preparation of the case, when we were trying to collect all these, we tried to ascertain about this position. And we were informed that the chief secretary is the chairman of the backward commission.
Yes, now
That's the
the
information we have received. And if the government is saying that there is no such commission, matter is there. So far as the backward commission is concerned. But let there be a definite instructions on the part of the government, so that that will be a basis for further steps also.
correct.
And government being the owner, and if they are not aware, what can I say also?
So who should be the right person or the right authority to actually say who is the chairperson of the Nagaland Backward Tribal Commission?
They can obtain instructions from the chief secretary. Chief secretary being the cabinet secretary.
Your Lordship, I have obtained instruction.
So what do you mean to say? What do you mean to say is that there is no chairman?
No, in fact, no, not chairman, but in fact, there is nothing called the Nagaland Backward Tribe Commission. The existence, Your Lordship, of this itself. And I have also.
I think you will also have to do some research on this. Whether actually this respondent number 3 actually exists.
Backward commission.
Ha.
It was constituted under Act. Let me
Just
verify that. But Lordship, that is one part.
Okay.
The other part is with regard to the filing of the affidavit by the
Yes.
government. Because there are earlier orders.
Mr. Imsong,
Where
Yes.
you were actually given.
Your Lordship, I'm very much aware of the earlier orders.
If you are
Yes.
aware.
But the thing is, by Monday I was expecting, I already sent for the signature.
Okay.
So by this week I can file. So
Okay, we give a week. In the meantime, you can also just ascertain
Lordship,
whether actually this backward so and so exists.
Lordship.
Okay. But Mr. Im Tim Song, this was the same prayer you made on 17/7/2023.
Your Lordship. Now I've already, sent the affidavit for signature. So I'm waiting for it. So by this week I can file.
No, 17/7/2023 also you had actually made a submission that you had sent the affidavit for waiting. You have sent for waiting.
Because there are some correction and the affidavit.
Okay.
Lordship, if fresh advertisement is issued, we are apprehending that. That is why urgency is because of that. Again, they will go ahead with the wrong ratio. Two advertisements have already been issued during the pendency of this petition, Lordship. For that,
So what you mean to say is that the government should first work out
yes.
the reservation.
And if they want to take more and more time, let them take, but then there should be no advertisement. But that will be.
You advise the government.
Your Lordship,
Advise the government.
at that point reflects. I can
Or-
file the affidavit by this week.
Or we will pass an order on the next date that if suppose something goes wrong with the hearing, we can always pass an order that any advertisement made shall be subject to the. So you expedite. Okay. Mr. Im Tim Song, the learned Additional Advocate General, submits that he requires further 1 week's time to file the affidavit on behalf of the state respondent. Stop. It is made clear that if no affidavit is filed on the next date fixed, this court shall consider passing necessary order in the case. Stop. In the meantime, Mr. C.T. Jamir, the learned senior counsel, shall also ascertain on the establishment of the chairperson, on the establishment of the Nagaland Backward Tribe Commission, listed after a week. Okay?
For admission, item number 15.
Please, Your Lordship.
Yes.
Your Lordship, on behalf of Inauli, you kindly grant 3 weeks time to file affidavit.
What is the matter about?
My lord, here the petitioners, they are here before this honorable court to direct the state government to let the petitioners obtain the benefit of ACP as per 2003.
Okay, SCP, MSCP.
MSCP.
Correct. Okay. Ms. Ayami, I think the relief sought by the petitioner is not something very serious. If they're entitled, they get it. If they're not, they don't get it. That's all. Who is you are handling the case?
No, Your Lordship, Miss Inauli.
Okay. MS AIME makes a submission on behalf of MS Inaholi, the learned government advocate, and seeks adjournment of the case for 2 weeks for filing the affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 2 weeks.
My suggestion.
For admission, item number 16.
Please, Your Lordship.
Yes,
My Lord,
please.
here I'm yet to receive instruction.
Okay.
Kindly allow me 3 weeks time.
Okay, ma'am? Yes. Mr. E. Tibapom, the learned government advocate, submits that he may be granted 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Stop. Prayer is allowed, listed after 3 weeks.
Much obliged.
Yes.
For orders, item number 17.
Yes.
Lordship, in this matter, the government is yet to file the affidavit, and service report is still awaited for respondent number
3. The others are, who is 3? Who is 3?
3. It's a private respondent.
Private respondent. Who is for the government? Mr. Vijmomi,
Lordship,
you're for the government?
no, this matter is handled by MS Bicham, Lordship.
Oh.
However, she is on maternity leave.
Okay,
So-
speech.
Most probably one of our colleagues may be handling.
Yes, I think since this days government has given long maternity benefit, so I think you will have to make certain arrangements.
Lordship.
Mr. Angami, please bring this notice, this matter to the notice of your government,
Yes, madam. Yes, madam.
and you liaise with the additional advocate generals
Lordship.
to actually see that the matters are distributed quick and fast.
Lordship.
Okay?
We'll make arrangement. Your Lordship.
Yes, please do that. The learned government advocate seeks for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks. Okay.
For hearing, item number 19.
Yes, what is the case?
Actually, the case pertains to selection of VCM.
Again,
Yes, Lordship.
selection of VCM.
Yes. But before going to the merit of the case, Lordship, I would like to draw your Lordship attention to one order of the Deputy Commissioner, whereby it is specifically said that if a villager is a member in a Watsan, that's the Water and Sanitation Board.
Watson.
Yes. Then he will not be entitled to contest in this year. Lordship, can you come to Annexure B, page 22?
That order has been passed by the Deputy Commissioner.
Yes.
And whether the Deputy Commissioner is competent to pass that order?
Lordship.
Because we have to go by the government rules and regulation, not by what Deputy Commissioner says.
Yes.
Yes, Mr. Tongpok.
Yes, Your Lordship, but
The government will be in a better position to explain. Because we are standing by the order.
Yes.
so far as
Watson, what about the Watson? Whether if he is a member of Watson. You are a member of Watson?
no, Your Lordship, he was previously.
Oh,
But
he was.
By the time the village council election came around, he was not. And the government record is also very clear. He is disputing the government record. That is the authority concerned has issued in the affidavit also, it is clearly there, the executive engineer, right? Paragraph 6 of
Just tell me the gist. Let me know.
At the relevant time when the election was held, he was no longer a Watson member. Even if the issue of whether Watson, a person who is a Watson member may be elected or not, is there. So at the relevant time, he was not. And the government record is very clear.
Yeah, but we also have to go strictly by the Village Council Act.
Your Lordship, there is
That's what-
nothing in the Village Council Act regarding that aspect of the matter.
So your only case is that he was a member of the Watson.
He's still.
How do this court actually deliberate on that?
Lordship, I have documents to show. I have documents to show.
So let us first adjudicate on that issue, whether a Watson member has a right to be appointed to the office
Now,
of the
Lordship, since your Lordship has
What does the Village Council Act says?
Village Council Act doesn't speak about.
When it does not speak about any of these Watson member, can we import?
No, Lordship, going by the order of the Deputy Commissioner, which the government has.
That's why I'm saying, yes.
This is the order of the Deputy Commissioner.
Whether the Deputy Commissioner has the competency to pass that order as per the Village Council Act.
As per the village council, as per the act, it's silent.
It's silent, and therefore can this court import?
As far as paragraph 6 of my affidavit is very clear. That here the petitioner has alleging a complaint to the respondent for the selection of respondent number 7 as VC chairman of VC member of Kohima project. And we have received the representation from the petitioner, and thereafter we have forwarded the matter to the executive engineer, PhD. Since the complaint is against that, saying that the respondent number 7 is a Watson member. So accordingly, we have clearly stated in our paragraph 6. Paragraph 6 that I have, this is the annexure that has been annexed by the petitioner. Annexure M of the victim.
What does the department says?
The department says that I have the honor to submit herewith the subject cited above, members of Watson Committee, Koyo Village, has been listed and updated in IMIS in official website. Following list. IMIS is Integrated Management Information System. Here, the name 1M Nakov Kikong, who is the chairman, and second, Nichembemo Dizun, who is a member, Rentemo Patong, who is also a member, and fourth, Yang Sungo Patong, who is also a member. So, if at all, the respondent number 7, if at all the respondent number 7 is the member of the Watan, his name should have been in the IMIS, but his name is not there.
The respondent number 7 name is not.
Respondent number 7 name.
Have you filed your reply to the affidavit filed by the state?
Lordship,
Have you filed your reply? Have you filed your reply?
No, Lordship.
You file it? Because actually you actually have to dispute that.
Lordship.
If not, actually your main contention is that he is a member of the Watson and therefore is not entitled to be a member of the VCM.
Yes, Lordship.
That is your main contention.
Yes.
Now, if you are going to stay quiet, you have impliedly admitted the affidavit filed by the state. That is the law.
Partially, they have admitted that there was some oversight while entering the names of the person members.
That we have never mentioned in our affidavit.
Okay. If you are not let us make it very clear. If you are not disputing the affidavit of the government, we'll proceed with the case. But if you are disputing, then you will have to file at least you will have to file a reply.
Yes, Lordship. Yes.
If not, the fact remains that you are admitting to the counter affidavit filed by the state. Mr. Tongpok, correct? See, this is a Mr. Jim. You are a seasoned lawyer. This is not for this court to actually
Lordship.
bring up all these issues during the hearing. The learned government advocate, the learned counsel for the petitioner, is allowed. Oh, sorry. Which item?
Item number
19. The learned counsel for the petitioner is allowed 1 week.
Lordship, it's 2 weeks, Lordship, because they have in place, Lordship. The conditions.
Is allowed
3 weeks time, Lordship.
3 weeks time
Lordship.
to file affidavit in reply to the affidavit in opposition filed by the state respondents.
Lordship.
But Mr. Tongpok, Mr. Government Advocate, on the next day also come whether the deputy commissioner will have that competency.
Exactly, Lordship.
That is also another aspect of the matter.
One is because we are totally relying on the order.
So whether the deputy commissioner has the competency to pass this order.
Yes.
Okay. Okay.
Obliged, Lordship.
For hearing, item number 20.
Item 20.
May I please, Lordship?
Yes.
Lordship, I am appearing on behalf of my senior Mohamed. Lordship, my senior has some personal difficulties to take up the matter. So can I release it after 3 weeks for hearing?
What is the matter about? Yes, Mr. Beto. You're for the government. This government advocate, they are not.
Lordship, I've taken consent from the government counsel, Sir Mohamed.
Moi. Oh. Maybe. Okay. So, but what is the matter about?
Lordship, the petition is praying for regularization. This work charge mechanical person.
Okay. Pleadings are complete.
Yes, Lord.
It is submitted by the. Oh no, this is for hearing, nah? This is for hearing. Okay.
Yes, Lord.
On the prayer of the learned counsel for the petitioner, listed again for hearing after 2 weeks. Okay.
Give your blessing.